Question 2. Does it matter that one spouse wants a divorce and the other spouse does not? Answer: no, it does not matter. In Washington State, we have developed a policy of no-fault divorce. This is something that came about in the late 1960s and early 1970s. What it means is the court does not determine who's at fault for the divorce. The court does not determine whether somebody has acted inappropriately. The court does not determine whether somebody has engaged in a form of cruelty or abuse. Now, that might be appropriate in determining whether or not a restraining order should be in place or whether or not there should be limitations on one parent's visitation with children. But the court is tasked primarily with 4 things. 1, dividing the property and debts. 2, making arrangements for the children. 3, providing for support for those children. And 4, potentially providing for spousal maintenance for the other spouse. That's it. The court does not get into determining right or wrong as far as how these parties have acted in the divorce. It does not mean that when the court is considering how to allocate property, that one party's actions don't affect how the court sees the division of that property. But generally speaking, the decision to whether or not grant a divorce, it's only a question of whether one party wants to get a divorce. It can't be prevented. Divorce is a very serious matter. It should not be entered into lightly. Marriage is also very serious. It also should not be entered into lightly. Children are affected, and both parties generally have long-term, long-lasting consequences as a result of this particular process. If you have further questions about divorce, if you have further questions about who can get a divorce, you can call the law office of Patrick McBurney at 509-374-8996. 509-374-8996.